in. Are we ready with recording and so on?
All set.
Okay, I'm Larry Willett, and it is March 21st, 2023 at about 9:10, and I'm calling to order the meeting of the Home Inspection Licensing Board. And so did everyone get copies of the minutes from our previous meeting? Have a chance to go over them?
Yeah.
Okay. Any questions or discussion on the minutes?
I do
Guess
not.
not. Okay.
No.
Do I have a motion to approve the minutes?
Motion.
Okay.
Second.
Mark, Tim, okay. And a vote, all in favor?
Yes.
Okay. So they'll be approved. Or any opposed? No, there's none opposed. Okay, there's not too many of us. Okay, so moving on with the agenda, any comments or concerns of anyone present today?
No concerns.
Okay. And then we have the department's investigation division. Are they with us today?
Yes, sir, Mr. Chairman. Supervising Special Investigator Janita Hamill is here.
Good morning.
I did send the report, and you all should have a copy of that spreadsheet, I believe, right, Jen?
Right.
Yeah, I received a copy.
Okay, so for the 2-month time frame from January 1st of 2023 through February 28th, 2023, we did not receive any new complaint cases. However, the special investigator did close 11 previous files, and one file, the 2019-13-20 file, ended up in an assurance of voluntary compliance at $200 because the home inspector had not renewed his license and worked on his license when it was expired.
Okay.
But all the others were either civil matters or disputes of fact, as noted in the comments and the information from the special investigator on the spreadsheet.
Okay. You guys
Mr.
have any
Chairman, would you or any of your members have any questions?
No, I myself do not. I was a little surprised to see all the activity, but the investigator's been busy closing out some of these.
Yes, sir. Yes, sir.
Yeah, I don't have any questions. I guess you guys don't either. Mark, Tim?
No.
Okay.
Okay.
All right.
All right.
So we
Thank
can,
you.
okay, go ahead.
No. I'm sorry. I was going to ask, no questions, no other information, so we're good?
Yeah, I believe so. Yep.
Thank you, sir.
Okay,
Thank
thank
you.
you. And now we have some information from the legal division.
Hello, my name is Julia. Excuse me. My name is Julianne Avalone. I'm the legal director at Consumer Protection. I just wanted to get a chance to speak to each of the boards really over time on procedures for remote administrative hearings. Now, I believe we did a presentation with the board in 2020 or 2021. Were any of you on the call? Okay. All right.
Well,
Well,
if your question was any of us on the board, was that going to be your question?
Well, were any of you on the call? Do you remember getting an administrative hearing? Okay. All right. That makes it easy. So I don't have to cherry pick what I go through. So if I may, I'm going to actually run through a document that we will send to the board to make sure You guys have all of the most recent information. Let me just open that up, sorry, close down. That kind of talks you through how we are doing hearings now, because probably the last time you guys were in a hearing, you were sitting in a room together and, someone came and presented. And now that we're doing this all electronically, it's a bit different. And some of the natural pauses that would happen in a hearing in person can get a little bit more awkward, we found, especially like, again, we have hearing officers that do this. So we have created a script that really, you don't have to read word for word, but that will help with the flow online and make sure that we're covering all the points to be able to give people an opportunity to speak and really put on their own defense. I'm going to share my screen. Oh, no, I do not have the authority to share my screen. Jay, can you give me that power?
Let me see. I
So-
think I can.
Oh, sorry,
Wait a
or Jen.
second.
So one of the big things that you'll see when we're going through this is that, some of the directions just wouldn't have been given in person, like, don't drive while you're going to be presenting. We have people that, we ask them to put their camera on so that you can still kind of get a better read on the person that's presenting. The biggest difference that I will say happens between the remote hearings and the in-person one is how exhibits are handled. So previously, you'd be sitting, up in front of a respondent and department counsel, and if they had an exhibit that they wanted to enter, they would just hand it to you, and then you'd review it. You could deliberate after the hearing if you wanted, but you would only be reviewing it then. So the issue now is that since no one can physically provide these to you, especially since oftentimes respondents will bring evidence the day of the hearing, what we ask is that everyone submits their exhibits in advance of the hearing. You should be receiving all exhibits 48 or 2 business days before the hearing. However, you cannot review them. So the sequence of documents you'll get is that when a hearing's scheduled, inside that invite, and I believe also in a separate email, you'll get the complaint, which will say who the case is against, generally what violations of law are there. You'll have the department's allegations, and then also what we want for the prayer for relief. The prayer for relief will say, suspend them, revoke them, do a fine. You do not have to follow what the department says, but it at least is a document that says what we're looking for, and then you can determine whether or not you agree. So the complaint we expect you to read. That should be about a month before the hearing. The evidence is going to come in, things that are going to support our case and the respondent's case. That's going to come in 2 days before. And those documents don't exist until the day of the hearing. They should not be reviewed whatsoever. Now, that being said, the question I always get is, I'm not good with reading multi-page documents on the computer. Like, I am still someone that I'm ashamed to say kills rainforests. Like, I just like having that in my hands. So if that also is how you tend to work, you can print these out. What I'm just asking you to do is don't look at them in any substantive way before the hearing. Just put them in a pile to the side, because the big thing with this is that, let's say that Cynthia is presenting a case in front of you. Then during the course of the hearing, although she's given you 10 different exhibits, she may realize it's not actually good for her case, or it's no longer relevant to provide exhibits 6 and 7. So since she's not entering them for consideration at the hearing, they just don't exist. When you guys are doing your deliberation, you can look at 1 to 5 and 8 to 10. But she decided not to enter those on the official administrative hearing record, because you have to be hearing this case for the first time that day. So I believe I now have share power, so I'm going to move on to my screen. just a few points. So generally, again, I'll be sending you this over that has the hearing script. But the one point on here is that, things go wrong. Honestly, very little in our experience with doing these online, which is amazing. But every once in a while, someone's going to lose their connection. Something, there'll be like a fire alarm in the building they're at. Whatever it is, you can always suspend a hearing if you think that maybe it's only going to go on for 30 minutes. Or you can say, we need a motion to continue to another day, and we'll work with the department to reschedule. Hopefully that doesn't happen, but good. So as the hearing, the same way that we're asking the respondents, we do ask the board members to keep their cameras on. It just helps the respondents stay more engaged, and makes it clearer for who is speaking at any given time. And as far as who's going to be actually running this is typically the board chair. But if it's not going to be the board chair for whatever reason, then you should figure that out in advance of the hearing, since it's kind of the presiding officer is going to run the hearing, although anyone can ask questions. So this is, let me see if I can make this a little bit, guys. So this is just, again, kind of a script as well as a Mad Lib in the beginning to help you figure out what information needs to be placed where. Now, remember I said that about 30 days out, you're going to receive a hearing notice. And in that hearing notice, this is where you're going to get this information that's listed as just a blank. So you'll know the case number, obviously, the home inspection licensing board. And then you'll know down here, this is really the crux of it, of who the respondent is, and then what sections of the statutes have been alleged to be violated and what sections of the regulations. That's all spelled out right in the beginning of the complaint. So you can do that the same way you did today. You're going to convene the hearing. And just, to note, obviously it's not a board meeting, it's the hearing. So the way, this is structured will be quite different. And then making everyone understand, mainly making the respondent, clear that this is an opportunity for them to be heard, that they will be able to cross-examine folks, that they will be able, that the rules that apply are the rules of the Uniform Administrative Procedures Act. So there are looser rules of evidence, and that they just kind of why they're here and what rules apply. So
I have a question.
Sure, absolutely, yeah.
Yeah, I have a question on just above, you scrolled away from it, but when someone is going to be recused from the hearing, if you know in advance that someone is going to have to be recused, does that be taken care of ahead of time? Or, for example, let's just say the presiding officer is going to be recused. And if that's the chairman, does he appoint someone ahead of time, or do you wait till this point in the hearing?
No, definitely you want to let people know as soon as possible, because also one of the things is that typically it would be me or our assistant legal director, Paulette Annan, that would talk to that board member to figure out, first of all, if it really is something that needs to, a conflict where someone needs to be recused, because we'll find sometimes with other boards, it'd be like, well, we worked at the same company 10 years ago, or like, oh, my son plays baseball with his son. And those aren't basis, that's not a basis for a recusal. Because unfortunately, sometimes what we see is that there are these industries that are so small, like the home appraisers. Find me a home appraiser that doesn't know the other home appraiser. Like it is, everyone's going to have some connection in the industry, and you find I'm picking on them, but like it's a lot of these industries. People have cross-pollinated on jobs or in different companies. So we asked to have that conversation with you first, and then from there we would let the board administrator know, because we need to have a quorum at the hearing, and then like you said, you have to, bless someone to be that presiding officer.
Okay, okay. All right, and so I had one other question on the evidence. Once we are within the hearing and we have the evidence, does the board have to make a motion to approve the evidence, to accept it, or?
No, so you don't have to make motions like in a regular meeting.
Okay.
So at the end, kind of as a functional thing, so you don't have to vote at the end either on the decision, but in terms of deliberation, if you have a split of the board in terms of who agrees with the decision or not, then I would put it for a vote to make sure that you at least know that the board is agreeing on what action to take in the decision. So, at some point, if you can't convince, some board members say it should be a $5,000 fine. Some people are saying that it should be a $20,000 fine. You can't reach a middle ground, then I would vote on it and then move it forward that way. But typically,
Okay.
I don't know that I've seen, maybe Cynthia has, but I don't know that I've seen that happen.
Okay. Well, again, getting back to the evidence, suppose there's evidence that isn't really appropriate for the hearing. Can the board reject it?
You may, yes, you have to actually accept every piece of evidence. So if there's something that has no relevance to the case, then you can certainly say that. And now also what you'll find is that if there's something that clearly is out of left field, like it is, not relevant, then the prosecuting attorney would flag that and say, motion to reject in terms of relevance, a lack of relevance.
Okay.
So, yeah, the attorneys on our side, they will generally help with the flow of the case or the flow of the hearing. If, in terms of knowing when they're going to be cross-examining, when they're done with their current witness, just to, kind of keep some of that flow. Although you guys run the show, this is, as the presiding officer, you're going to be going through this. So again, let's go into kind of the format of how things will flow. So you let folks know, short opening statement. After that, you start calling witnesses. Now, I will get down into it a little bit more below, but I do want to note that opening statements, oftentimes, so, we will go first, then the respondent, but respondent oftentimes, this is their first time to talk. You haven't asked them a question. This is just like, an open forum. A lot of times they're going to want to tell you their whole story right then. This is supposed to be like, a paragraph, a couple minutes at most. So you may have to say, please, we'll put this to after when we start having witnesses and entering in testimony. So that may be a thing that you have to kind of cut off a little bit. And then they can cross-examine. So the documents, this gets into your question from before. So documents can only be exhibited as evidence if you have the agreement of the parties and then based on your review of relevancy.
Okay.
So, and again, just reiterating, just because you sent it in before doesn't mean it's on the record now. We want them to be very clear on that so they don't just assume you have things. Now, these are just kind of the hearing instructions of keep your camera on, might mute yourself when you're not speaking, don't disclose confidential information. I'm going through some of this faster only because usually this is a longer training for the board and I don't want to monopolize all of your time, but again, you'll have this document. And then, so you're going to confirm who's going to be there today. So asking the respondent, are you represented by counsel? And then having them actually introduce any of the witnesses that'll be there today. They also should have sent their witness list in advance. Here's the thing, they may not have. And if they did not submit a witness in advance, we're still going to let that person testify. So this, they have to name them for the record, because I should have said this at the beginning. One thing to remember when you're doing this hearing is that we have to have a transcript. I think a lot of times, and again, in person as well, but people will tend to nod or do body language. In order to have a transcript in case any of these cases are appealed, your agreement or any objection needs to be audible. Okay. So then you're gonna swear in the parties, and depending on how many witnesses there are, some people want to swear in, like, read the statement of do you solemnly swear, to each individual person, have them each affirm. You can also, as long as someone proactively says, I do and I accept, you can just say, do you solemnly swear, read the statement, and then just call out the people's names and have them all say I do, so that you don't spend a ton of time saying it over and over. But some people want to say it over and over. It's up to you.
But there's typically a list of those witnesses, so whoever's administering the oath will know who they're going to administer, and then just say,
So-
I do. They would say, I do. You just name them.
Yeah, so when you're confirming the participants, this is why you're going to have them introduce, and then they have to state and spell their name for the record. Because what you should be doing at that time is taking down each person's name
Okay.
and writing who they're associated with.
Okay.
Because you will have to then, say their name and swear them in.
Okay.
Then the hearing starts. So this is what now when you're going to start receiving evidence, you're going to start. Let's see. Oops. Oh, sorry, I lied. Once again, so you're going to start with the opening statements. We had talked about that before. Then, and in here, you'll just see the order generally. So if people want to make opening statements, department goes first, then the respondent. And then it's always sorry, I didn't mean to keep scrolling on here, but this is always like the most interesting thing to me, because it's from that time of opening statements. Now there's like this very small line down here that says complaint counsel may now proceed. This means like open up your case. So now they're going to start calling witnesses. They're going to start entering exhibits. This is like the whole meat of the case, kind of is in these two lines. That being said, it's not a prescribed way of the case kind of playing out, other than calling witnesses and then having them enter in exhibits. So basically, we've skipped through the whole case at this point in those two lines, and now we're at the end. So once everyone has called their last witness, then you're going to go to closing arguments. People don't need to do closing arguments if they don't want to. If they feel like they've said everything they want to, that's fine. But if they choose to, this is your moment. And then for the board deliberation, this can be done different ways. Now, if it is a very clear-cut case and you feel like you don't need to have a separate time to deliberate, if it's not going to be something where you feel like you really need to read all of the exhibits and go back and think more about it, then we encourage you to deliberate now at the hearing, because either way it has to be done on the record, and then come up with some conclusions, which would then turn into a decision drafted by a proposed decision drafted by the department for your consideration to approve as the final decision. So so for the board deliberation, there's really three main parts. So the first thing is going to be, in decision, you have to have the findings of fact. Now, a good roadmap for that is going to be the complaint that was sent to you in 30 days in advance of the hearing, because that's going to have the allegations listed in the complaint are going to have, respondent was licensed from X time to X time, they engaged in this. What you need to do, though, is going through those findings of fact. You really have to discuss whether or not you agree that the department actually proved its case by a preponderance of the evidence. Not beyond a reasonable doubt, just by a preponderance of the evidence. So if you go through those, it's important though that we provided a complaint so you can talk about those findings back, but also you should be adding in there any compelling information that you found to be true that the respondent presented. So those are generally what happened. That is the story behind it. Then you have to go to the conclusions of law. And in there, this is going to be based on the fact that, they were doing certain work outside of the scope of their license. They were, they were engaging in fraudulent activity in terms of taking people's money and then not really doing inspections, whatever it was. Then this is where you're going to say, because of all of that, they violated this law. And again, those are going to be listed out in the complaint. So it'll be, they violated section 20-330AA, which means like this is the law that they violated. So you don't have to guess, you don't have to do your own legal research. And then in the order section is, so what? So all these things happened. We found that therefore they violated the law. So what's the penalty? Is it a letter of caution? Is it, some kind of conditions on a license? They have to report in X information for a year, like whatever that is. But usually what it looks like is it's a civil penalty, suspension, or revocation. And in the prayer for relief, again, we will have asked for something, but that does not mean that you have to agree with us, because also the respondent may have additional information that they didn't share with us during the course of an investigation that only comes out during a hearing. It shouldn't happen, but it does. Like, it's just real life. So if that happens, you may decide, and it's happened before, that really we should be giving them just like, again, letter of caution, some kind of slap on the wrist, that it really wasn't a violation the way that we thought it was, or maybe we were missing some evidence, there wasn't a violation at all, and you just dismiss the case. Either way, totally fine. When I say dismiss the case, that you rule against the department. The department did not meet their burden of proof. Now, there are going to be more complicated cases where something comes out and you're not really sure if it is a violation of law, or you're not sure if it's separate violations that you could charge a fine that you thought was sufficient. Whatever it is, if there is a substantive legal question, then your attorney will not be there that day. Your attorney is Rosemary Weber, who's over at the Office of the Attorney General. So you will have to say that you can't reach a conclusion right now, and then you can close the record and consult with them. I'm going to get down to that a little bit more here. So generally, there are three ways that you're going to close out the hearing, and I have a little script for each of them. So one is that you get to the hearing and you have a home inspector that's like, despite everything that we presented today, they're like, it's okay because it was in a contract. I had this contract with this homeowner. Like, it really, I did the work exactly how I was supposed to. They said not to inspect, anything in the basement. And then that's fine. You're like, well, where is this contract? Like, if I can see this, then it might, be dispositive of the whole case. So they say, well, it's at my ex-girlfriend's house. I'm not gonna be able to see her till next week, but I promise I'll get a copy and I'll submit it. If you think that whatever that piece of evidence is that's being promised by either the respondent or the department as something that they're going to get shortly, and you think it'd be crucial to the case, you can keep the record open to receive that. What we do ask is that if you're going to close the hearing for everything except for like one document, you name what you're going to be waiting for and you give it a time period. Because otherwise we can get in a situation where you're just they're holding up the hearing forever because, there's no deadline at which time the case closes. So here's the script for that. So it's, when you get the specific exhibit from whomever, we put in 5 calendar days, but it could be, again, in my situation that I was just referencing, maybe it's 10 days. He's not going to be able to get it for 7, but that's fine. You guys make that decision. The key is that when that is sent in, then it needs to go to the board administrator and it needs to go to the plaintiff, or the defendant, or the department's counsel rather, to make sure that you accept it as a board, and relevance, materiality, and then also that the department does not have an objection. If no one objects to the submission of that exhibit, then the decision, or sorry, the case file is, the record is officially closed, and then you can deliberate at that time. Again, it's typical that we give people, the department and the board, 10 days to review the exhibit, and no objections, then you just move forward. And I'll talk about deliberation. Well, actually, I guess I'll talk about deliberation here. So, and there's further above, we talked about deliberation on the record. You guys just go through and talk about it there. Same day as the hearing, you don't need anything else. So here, you're going to need the additional exhibits. You will have to reconvene as a board in order to discuss how you want to rule on this case. Now, people find it uncomfortable, but it by Freedom of Information laws, you have to deliberate on the record. Unless you are going into executive session to speak to your attorney at the Office of the Attorney General. If it's not that, then it has to be public. So after you get that, we would work with you to schedule another time to discuss and then rule on the case. So here, if you do reach a decision that day, then in order to have our department write up the hearing decision, we want to make very clear exactly what's being ruled on by the board. So here, which laws did they violate? And then what are you going, what is the penalty that the board wants to impose? What we will say that is also really important is that if you're going to impose a civil penalty, then how much time do they have to submit it? And then if they don't submit it, what happens? Because what we found in the past is that if there is, you say we order a fine of $10,000. Okay, how long, if they have forever to pay it, then usually what just happens is that we put a warning on their credential for the time of renewal, but if they just renewed, that could be 11 months out. So rather than handling it that way, usually it's 30 days. It could be shorter, it could be longer based on certain circumstances that you determine, but usually it's 30 days. And then if they don't pay by that certain time, you can say their license is suspended, their license is revoked, whatever you think is appropriate. Or sometimes, or if you have that latitude in terms of whatever you're fining, which you'll usually have that bandwidth in the prayer for relief, then you can say, you're being charged $500 if you pay by April 15th. If you pay after that, it's $10,000. So you can decide there. So and if you hear it that day, then the record's now closed and you have to issue the decision within 90 days. And talks about how they can appeal. So, and then this
Right, so I
last
have a
one.
question.
Sorry, yes.
Yeah, I have a question. If there's a civil penalty, that would be a fine. Is that what you're talking about by civil
Yes, yeah.
penalty? Okay. So if there's suppose there's a suspension, there's no civil penalty. Wouldn't the respondent have a right to appeal that?
Yes.
Okay. And we also have this written decision within 90 days. That's from the department, right?
So we
So-
will draft a proposal for you, and then we will send it over to the board chair to confirm that it is accurate based on what was discussed that day and what was, just based on your, really, based on the meeting. And then if you confirm that it's accurate, then you'll sign it and then it'll go out. We'll handle
When does
that.
it become effect? If there is a suspension, for example, when is the person suspended? Right then, or after they receive this final decision within 90 days? When does the suspension take place?
So it's partially up to the board. So I guess typically the board will say when that suspension will become effective and how long it will be. However, if you do not, then they would be suspended upon delivery of the final decision because it is effective upon delivery.
Okay, so it's like 90 days because the department has, that's what it says here. You have 90 days to write a final decision.
Well, we have to send it out to them
Well, then-
within 90 days. So hopefully we'll have it to you much shorter. And also, if it's something where you're talking about a suspension and there's, a public health and safety issue that we really feel like needs to be addressed more urgently, we'll get it to you faster. Like that is certainly something that the prosecuting attorney can flag for me and say, because of the egregiousness of this, we need to move. But then we also have sometimes recently we had a case about failure to take continuing education, like 2019. They were going to get a fine and they're like, they could pay it, whatever. And so that may be, fall lower down on the list in terms of priority of writing these decisions for us than someone who may be missing, explosive materials in people's homes on a regular basis.
Okay.
And so this circles back to this idea, though, that I was talking about before, that if you need to review legal issues, then you're going to close the case, you're going to close the case in terms of accepting any more testimony or evidence, but just informing the respondent in the department that you will be consulting with the attorney in an executive session. And then after you have that executive session, you'll come back out to the regular public meeting and you'll have to announce your decision for the that will then be drafted. So we would have our person who's going to be drafting the decision for you in attendance that day to make sure, and they know what the findings of fact, the conclusions of law, and then orders are. And that is it. I know that was a lot of information, but that is.
Okay. Can we go back to the deliberations piece then? Just scroll up that finding of fact, conclusion of law, I guess, and then the order. Now, you're saying that once we deliberate that, the board doesn't have to call for a motion to accept any of those three, or how?
So the Robert's Rules of Order don't apply, but upon deliberation, if you think that, you can certainly have a motion for the board to vote on just to make sure if there's someone that's been silent and you want to make sure that everyone's on the same page, you can certainly do that. Typically through that discussion, you're reaching when you're saying here are the conclusions, here are the orders, usually if someone did not agree on the board, they would be speaking up. But yeah, you can certainly do it. It's just Robert's Rules of Order that apply for a board meeting don't necessarily apply for the board. But
well, I had questioned that before, and I was told that we are going to make motions, or we should be making motions. So I'm not. I just want to be clear on the right procedure.
I think at the end, it's never going to be bad to confirm with your fellow board members that everyone's on the same page with the findings of fact, the conclusions of law and orders. So I certainly, I encourage you to do that, but it doesn't need to be like a motion and a second, all in favor, any opposed.
Okay. Okay. All right. That just seems to be the easiest procedural way to do it, and you can do it if we want.
Yeah, you get, nothing's stopping you from doing it, absolutely.
Right,
Um,
right, okay.
But if you, I guess, for my purposes, if you didn't follow the orders properly, if you didn't like say, okay, anyone recused, blah, blah, that's not going to, you know, negatively impact our case if you don't specifically follow the Robert's Rules of Order. But yes, if you do, then that's very clear as well.
Okay. Okay. I think I'm all set.
So Cynthia, you're here. Cynthia actually runs these. So I don't know if you have anything else to add that you think would be helpful.
No, yeah, I think that pretty much covers it. But I, you know, as Laurie was asking about that voting, it is kind of practical to have everyone state on the record their opinion, you know, as to whether or not they agree that I've established the case or I've proven every aspect of the complaint. So it kind of does end up looking and sounding like a vote because we're getting everyone's, you know, opinion on it. So it's kind of practical that way, as long as, you know, we have a record of what everyone believes I've established or not, whether or not I've proven my case beyond or by preponderance of the evidence.
Great, that makes sense.
Okay,
Good.
okay,
So I will send, actually, I guess I'm going to send this to Jen because I don't have everyone's emails, but Jen will send out this document to you shortly, and I'll make sure that I have my contact information in there.
okay.
If you have any questions, then let me know.
Thank
Okay.
you.
I'll
Good.
also, since you guys have a new, well, relatively new, maybe, actually, I guess a little over 6 months, representative over at the Office of the Attorney General, I will also send her information along. Again, just in case you need her after the hearing to deliberate.
Okay, yeah. As long as we have some contact information, if anyone has any questions once receiving this script, they know who to get a hold of, whether it be Cynthia or you. Okay, that'd be great.
Wonderful. Well, I'm going to drop off Jen rather. I don't think I had anything else on the agenda. Right?
Thank
Okay.
you.
Thank you.
Thank you.
Okay. So we're still with the legal division. Was there anything, Cynthia, did you have anything for us?
No, I just had a quick update on the regulations, just to let you know. I'm not
Yes.
sure if you're aware yet that yeah, they're posted for public comment at this point since February 27th, and that period closes March 31st.
Okay,
The next
so-
step after that would be to go to the AG's office.
Okay, so we have moved past the governor's council, their office.
Yes.
And
Right,
so
exactly.
I'm
and
looking at this,
Office
I'm
of
looking at
Policy
this
and Management.
regulation review process.
Right.
And so we're now at regulation draft is being sent back to DCP for revision. So apparently there was no revision needed or suggested.
Right, exactly. So it did go, we're at D. The public comment period runs for at least 30 days.
Right.
Right. So then the
Okay,
next step would be once that public comment period closes, we would gather all of the comments.
Okay, so
put
that,
together
all
a,
right, so
like it says in
all right,
E,
so-
the notice of decision.
yeah. Back when we had discussed this before, I had thought that we were going to be told when this went to the public portion. Because I get calls all the time, and so do, I don't know, Mark, have you had any inquiries from
We've
guys in
had,
Ashley?
yeah, we have, not lately, but
Yeah,
I've been trying to keep our membership up to date on the movement of this through the process.
Right.
There was a schedule that was sent out. I thought it might have been around the beginning of the year, or maybe the end of the year, but we haven't had any updates on where it's in that schedule. So, but
Well,
I
that
think
might be
there was-
this-
I can forward you the link that you can make comments online through the E-reg system. So I can forward you all the link, and you can forward that on to anyone, then they can make public comments right online.
that'd be great, Cynthia.
Right.
Thank you.
that would be
Sure.
good, because I know inspectors were anxious to to read these amendments through the public portion. And now that's going to end in a couple days. Is that what we're saying?
The 31st,
31st. Okay. Okay.
10 days.
So yeah,
Right, right.
if you could get that information to us, then we can get it out.
Yes, definitely. I'll
Um,
send that right after we're done.
Okay. All right. And so as of the end of March, then we'll be moving on to step E. Looks like.
Right, exactly. Exactly.
All right, that's good. Was there anything else, Cynthia, that we needed?
No, that's it.
Okay, okay, we can move on. Is there any old business that we want to discuss? Mark, Tim, anything?
No, I'm up to date.
Okay, okay, new business. We have, we're going to revisit the resignation of Rich Kobalinski. I think we need to, he submitted a letter, and I think we need to get that letter onto the record. And Cynthia, maybe you can help me with this. If do we need to read the letter and then just ask for a motion, not a vote, but just a motion to approve his resignation? Is that the protocol here?
I'm actually not sure. I guess it wouldn't hurt into the record. I've actually never dealt with a retirement. I'm not sure.
I can make a motion to accept his resignation upon receiving his letter.
Okay. I'll second the motion. And do we have a vote to approve his resignation? Aye.
Bye.
Okay. Is that all we need, Jason? You think? Is that enough?
Yeah, that should be fine.
Okay. All right, so we can move on to other new business. We have a hardship waiver request. Did everyone receive that information from a Sue writer? Had a chance to look that over? Mark,
Yeah.
Tim?
Yeah, I did.
Any discussion on that? I think that, go ahead.
I'm sorry, Larry. Is it appropriate to ask if there's a way to get this person's contact info? Because we presented an online review of the legal course the month after the CAHI meeting. We would have been able to do that for her. And, I just want to make sure that if there are people that are out there that aren't either in CAHI or, ASHI, that they're aware of what we're offering for these courses for CE. And, if we can get in touch with them, there should be a way that they can have access to at least my contact info, or, I know if they're a CAHI member already, but they can't attend, they should have an option to do that. How do we make sure that, licensed inspectors in the state, have these resources so they can reach out if they wanted to attend a different meeting?
Okay, so this meeting was already taken place though, right?
Well, from what she says in her letter, that she couldn't attend the March meeting because they rescheduled it, and then she had COVID or something. But
Right.
we had a meeting she could have done online. We had a virtual presentation of the law review that she could have attended.
And that was through the Coastal ASHI.
Yeah,
Is she a member of Coastal ASHI? I don't
she's
think so.
not, but we would have let her attend, and we could have handled that for her.
Right, but how would she have been aware of your meeting?
Well, that's just it. I don't know. I mean, is there any way that,
Okay.
how do we get this information out there if there's people
Well,
like that?
Aren't there still, if there's online courses she could still take?
I don't know of any for specific to the Connecticut regulations.
Yeah, I
mean,
think that, I do think that there's one organization that has it.
Yeah. Well, she said she attempted to find providers and she didn't have any luck finding them.
Okay.
So the bottom line is she hasn't taken it.
Right.
It's a repeat course, I mean, we've all taken it over and over and over. And she has mentioned that she has taken it, several times. I'm inclined to just accept her request for this cycle. That's my opinion.
What's the requirement? Is it every 2 years?
Yeah, one time during the 2-year cycle, right? And the way they've been handled recently, they've been just a review of the regulations, line by line. And so that's the bottom line, though. She can't find anything now, unless we want to get back to her. If you guys know of this course, Bruce, you say there's a course you know of?
Yeah, I'm trying to look it up right now.
Okay. Well, I mean, I don't know. Do we want to put this off until we can find the information that she could maybe take the course between now and June? Or do we?
Well, does Mark have the availability of having her look at that now that he has videotaped?
We don't have it videotaped. No, it was a live, it was a
Oh,
Zoom
it was live.
presentation.
Okay.
We
I
can watch
apologize.
it.
I thought you had videotaped it.
No,
Okay.
I could look into that though to see if it is available on a video.
Okay. So it doesn't look like, Bruce, you're able to pick up on
Yeah,
that.
I'm trying to get it here. Hold on. Home inspection course. I thought it was like
Well-
McKesson or something like that.
McKissock Learning,
Yeah,
McKissock.
right. Yep.
They have full courses that are certified or approved by the state of Connecticut,
Right,
and one of them is law.
that's right.
It is.
Yeah. Yeah.
Okay.
So she
Well,
could take that online.
I mean, I don't care one way or the other. I mean, if she has a
Yeah.
substantial, hardship, but that is online. I take it just because they send all the documentation right to Connecticut. So I don't have to worry about trying to make sure it gets sent from,
The credits,
Right.
the credits return.
How-
Yeah.
how-
just
are
a
you
peace of
spelling
mind. I
that?
don't have to worry about it.
How are you spelling that?
Capital MC, capital KISSOCK.
Right.
Okay. Well, then procedural wise, I mean, do we, reject her request at this time and inform her of that capability of taking the course through
Well,
this
I mean,
time?
she's already missed the deadline, I believe, so you could grant an extension for her to complete this by a certain date.
Okay. All right, so can I have a motion then to extend her time in order to give her a chance to take this test or this course? Maybe
Yeah,
60 days?
I'll move to extend.
Yep,
Okay.
I'll accept.
All right,
I'll
so we have a
second.
second.
Yeah.
A vote to approve?
Just to clarify, what is the extension? Is there a date or a number of days that you're extending?
I think 60 days is appropriate, right?
Yeah,
Right.
Okay,
I agree.
okay. So we have a motion and we have an approval. Any opposed?
No.
All right, so I think the
So
motion
is someone
carried.
going to reach out to let her know that there's this available? Like, how's that going to be handled?
Right,
Yeah, we'll let her know of your vote and provide some of the course information. And if she has any questions, we'll direct her back to you guys.
all right, that sounds fair. Any other discussion on that? Any other new business that anyone has to bring?
No.
Okay, any correspondence? Any comments or concern of anyone present today?
Larry,
Okay.
something, I don't know if you got a letter on this, but one of our members, I thought, sent something to the department. There was a realtor in Lower Fairfield County that was offering exclusive access to clients for a fee, $3,000 to be a part of this exclusive concierge program. And I just wanted to bring it up because we felt that, this sort of access was unethical, and it really goes against a lot of what we, follow as home inspectors and how we do business. To have to pay a fee where you're getting direct access exclusively from realtors for home inspection business, I think goes against, a lot of the things that we agree to when we come on here. So I don't know if you got that. I can follow up and get you a copy of that letter if you need it, but just
I
to get
didn't,
your
I,
thoughts.
yeah, I did get any information like that, and that was sent to the department somewhere.
Yeah, I believe so.
Okay.
Steve
that-
Gladstone sent something.
Okay. And that's how you became aware of it, from him?
Yeah, and he brought it to my attention, correct?
Yeah, yeah. I know that came up many, many years ago. There was a real estate company that offered the same thing. You could pay the real estate company as an inspector. You would pay them, and you would, get their referrals.
Yeah.
And that never got that, that was unethical, per our regulations.
Okay.
So
I just wanted to bring it up and have at least have it on the record.
yeah. Okay. Does anyone at the department, Cynthia or Jason, has anyone received, or our administrator, Jen, has anyone received
This is
anything?
Cynthia. Yeah, I
Yep.
haven't been made aware of that. I haven't seen that. I don't know if investigations has received any complaints regarding that though.
Okay.
Mr. Chairman, this is Supervising Special Investigator Janita Hamel. If I
Yeah.
could ask Mr. Champagne a question.
Sure.
You're,
Sure.
the person making the complaint is a home inspector against the realtor.
It wasn't, I don't know necessarily if it was directly a complaint, but I think he was raising a concern that this was not in line with how we typically, do business as home inspectors.
Right, so he wasn't making a complaint to my unit about another home inspector. It's about the realty company.
It was about a
Okay, then
specific, yeah,
then that would be a complaint that would have gone to the real estate the real estate unit to
Okay.
look at. It would not be something that myself or my investigators or my inspectors will be looking at, because the complaint is not made against a license holder that we oversee or report to you on. So if it was about the realty company that Mr. Gladstone filed the complaint, then at some point in time, the real estate unit should contact him if that's where it went. I believe that's where it would typically go.
Okay.
And you spell the gentleman's last name as Gladstone, Gladstone.
Correct.
Okay. I can't do it right now because I'm not in that system. And if I get into our licensing system to check on it right now, I'm going to get kicked out of this meeting. So, I will check later and see if there was anything received. And, we'll make sure if it didn't get to the real estate people that it is sent there.
Thank you.
You're
Okay.
welcome, sir.
Okay. Any other discussions or concerns from anyone?
No.
Okay. Do I have a motion to adjourn the meeting?
I make a
Motion.
motion to adjourn.
I'll second
Okay,
it.
so we have
I'll second it.
Champagne and Needham, and all in favor?
Aye.
Aye. Any opposed? Okay, I think we're adjourned. Thanks for everyone for their information.
Thank you.
Enjoy the
Thank you,
spring.
Mr. Chairman. Thank you, board members.
Thank you.
Thank you.
you. Okay.
Have a good day.